In commercial real estate, the traditional rule is that properties are sold as is, caveat emptor, buyer beware, and the purpose of that is that the seller is not going to be responsible for any defects in the property. It's up to the buyer to do their own due diligence and investigation, and that may work well for building defects and other types of problems with the property, but for environmental issues, the as-is provision will not protect sellers.
A seller that sells property as is could still be sued by the buyer under environmental statutes and also under common law. So it's important for a seller to understand that that will not protect them and that they need to have special language in their contracts that would provide for the buyer to waive any rights that they might have under environmental laws and also under common law.
So, in other words, a buyer won't be able to bring a breach of contract action because it's an as-is deal, but they could bring an environmental cost recovery or contribution action for damages for cleanup costs under environmental laws or under common law, like trespass nuisance. If you are selling a property and want to make sure that the contract adequately protects you from environmental liability, you will want an attorney like Larry Schnaff on your side. With over 35 years of national environmental transactional experience, and as a law professor, Larry has seen it all and is uniquely qualified to handle the legal issues commonly encountered with environmental issues and can help you come up with creative solutions to prevent environmental issues from killing your deal. There is a lot to consider. So if you're looking to buy commercial property in New York, be sure you are on solid ground. Call Larry Schnaff today or visit schnafflaw.com.